and post-judgment discovery of the documents that I am seeking. I did bring, I don't know if the court would be willing to give me more time, I gave more information.
Thank you very much.
I have 10 seconds.
Yeah.
May it please the court, let me state for the record the appearance of my co-counsel, Assistant U.S. Attorney Roger E. West, and of myself, Assistant U.S. Attorney David A. DeJute, representing President Obama and the other federal defendant appellees. This is a limited matter before the court, and unless there are any questions, I will not...
Where are you from?
The U.S. Attorney's Office, sir.
In L.A.?
In Los Angeles, yes, sir.
Yeah.
It's a limited matter before the court, and unless the court directs otherwise, I will not respond to the things outside of this court's purview, other than to say that there was no undue influence addressed to anyone, and that we acted in a proper manner. The issue before the court is standing. And as this panel has already suggested by its questions, the difficulty, of course, is that these plaintiffs did not have standing at the time and have not acquired standing in the meantime. The problem with standing is that they need to show, as this court well knows, injury in fact, redressability, and neither prong of those elements of standing, as the district court below correctly found, can be shown.
Now, is there nobody who could bring this case, or nobody who, or a case like it, a case challenging the qualifications of the president before or after the election? What about before the election?
In the abstract, I think there are certainly, if they acquire in a court of limited jurisdiction proper standing, I would concede that I could hypothetically think of some instances of a person who might be able to bring the case. And I think the first person that comes to mind is, as Your Honors suggested, is a candidate. And I think, as Your Honors also suggested, we don't have any candidates in this case. By the time this case was brought, the election had been run, the president had been certified as the president-elect, and in fact the president had been inaugurated, and that's when the case was filed, not served. The time for challenging somebody on the ballot had long since passed. There have been
And first of all, I gather that if we accept your standing arguments, we don't get to political question.
I think that is the correct timing, Your Honor, yes.
And if a case like this were brought before the election, would there be a political question problem?
There could well be. I don't believe a case has been brought where there's been a sitting president.
No, I'm talking about a non-sitting president. If you had a challenge to a candidate, I assume there wouldn't be a political question at that point.
Let's suppose somebody's running for office, declares and is 23 years old, or what is it? President, you have to be 35, right? So 33 years old. Nobody disputes it, but nobody acts. Would you say that somebody would have standing to challenge that?
It depends on the timing. Certainly
during the campaign.
During the campaign, I think that a candidate would have standing to challenge.
And it wouldn't be a political question.
And it would not be a political question, Your Honor. I think a candidate can challenge the qualifications of another candidate, assuming, of course, that that candidate does so in a timely manner, while that there is enough time. And there have been cases, of course, like that. And the courts can act promptly and swiftly when it's necessary. But assuming that that's done prior to the ballot, prior to the election, in enough time that the courts can adequately adjudge that the person is 33 as opposed to 35, I think the other candidates would be the proper people in front of this court.
Sort of like the Chicago mayor's race, when the residency of Rahm Emanuel was much in dispute. So that would be the kind of timing that candidates could challenge the qualifications of their putative opponents.
That's correct, Your Honor. There have been a series of cases that Ralph Nader has brought in challenging qualifications of other candidates. He's done so during the course of the election, and I would submit that, other candidates can challenge on the ballot other candidates' qualifications. That, of course, did not happen here. And, of course, to Your Honor's other point about redressability, what is the effect that a declaratory judgment would have if the district court were to ever get that far, other than to be advisory. That is to say, if the district court does not have the power, once the president has been declared the winner, the president-elect is sworn into office.
Well, there would be a nice and difficult question if the case were brought before the election but not decided before the election.
Yes, that would be, and of course the timing is such that the longer you go back in time, the greater likelihood that the standing might be.
So it could be that there might be a situation in which you would not have a decision on eligibility until after the election, and that would be sort of a hard and difficult question, but it's not our problem.
That is correct on both issues, Your Honor. One, that it is possible to think of hypothetical issues, and two, that is certainly not the issue before the court. The issue before the court is whether these individuals timely brought a complaint so that federal court of limited jurisdiction could establish that the plaintiffs had standing, and of course it remains the plaintiff's burden to establish standing. The defendants came in this case, challenged standing, and the district court correctly found that under both prongs, lack of injury in fact, and lack of redressability, these plaintiffs did not.
The redressability determination was really a political question determination, and it doesn't seem necessary.
I think that the court could have reached just the issue of injury in fact. Quite frankly, I think the opinion below never reaches the conclusion that there were candidates involved. It never makes that decision. It simply stops the injury in fact analysis and says that the most difficult, I'm quoting, paraphrasing from the district court opinion, saying that the only ones with any potential standing were the political candidates. It sort of stops there. I think another step in the logical process would have been to say, but of course, these were not political candidates at the time that the complaint was brought. The court later ties that in at the end, but it then goes on to talk about redressability as a means of establishing that, I think it's fair to say, even if the court were to get over the fact that there was injury in fact, there still is no redressability.
Even if we did need to get near the political question, I was a little concerned about you tried to point to textual commitments to in the Constitution to other branches, but they're a little vague, are they not? And then there's, well, what provisions of the Constitution do you think are committing these eligibility determinations of an officer, of a candidate or an officer, I mean an actual official, to Congress, the Electoral College, or somewhere else?
Right. Well, it isn't that general, Your Honor.
I'm sorry?
It isn't that general. It isn't a federal official or some other person. It's the sitting president.
Okay, let's take that.
That's a distinction worth noting, because the commitment to the House is that that body has the sole authority under the Constitution.
To impeach.
To impeach, and that the Senate has the sole authority.
But this wouldn't be a ground for impeachment, would it?
Wouldn't it be a high crime and misdemeanor? I don't know. We're in the area of there has been clearly no case law on this. But I do know that if the Constitution says that the only body that can remove a sitting president is the Congress in both houses, then the...
Where does it say that?
Well, I just suggested, and you did accurately say impeachment. The House says that the House has the sole responsibility to impeach. The Senate has the sole responsibility to convict. And in the Nixon case, the United States Supreme Court has cautioned courts to allow impeachment proceedings as a quintessential non-judiciable element to stay away, because that is what the Senate has the sole responsibility to do, and by definition, therefore, not the courts.
So if someone discovers that the candidate for president is underage or not a citizen,
yes,
not a qualified candidate, not qualified, and they discover it 3 days before the election, and they don't get to file the suit because there's no time. If they had filed and known earlier, then the judicial branch would be the arbiters of the qualification and defining what it means to be a natural born or how you measure the age or whatever. Is that correct?
I don't want to speculate.
That's how you envision it.
I don't want to speculate, Your Honor, but I do acknowledge that courts do know how to act quickly, and even 3 days before the election.
Well, I understand that they might have been able. I'm just saying that assuming they couldn't, so that the fact of the alleged fact of disqualification was discovered at a time when they weren't able to bring it, and so bring it to the federal court. If they had earlier, the federal court would have been able to, but the operative event then becomes, once the president is sworn in and becomes the president-elect, the ability to deal with the situation, the jurisdiction, if you will, under the Constitution, shifts to Congress. And Congress not only now has the jurisdiction to decide what to do, but also to decide the interpretive issue of what the Constitution means by being a natural born or other kind of citizen. And that's where the shift occurs. And in the course of deciding whether to impeach or exercising authority under Article 25, perhaps, or 25th Amendment, rather, that interpretive process authority would be in the hands of the Congress.
I would submit that that is a very accurate summation of what our understanding of the Constitution is, Your Honor. That the operative event is the election.
And you're saying, therefore, if the court if they filed as they did here, after the president was sworn in, the court would have no role in passing as a matter of declaratory relief only.
That is correct, Your Honor.
You said that would be an advisory opinion at that point.
Because there would be no means to enforce that opinion, because the court wouldn't have jurisdiction. And Mr. Kreep's suggestion that the declaratory judgment would then somehow be submitted to Congress, I don't think accurate reflects how the system works. There is no means by which the court would enforce its order. And at that point, because the election had already passed, it then devolves onto Congress to establish what the Constitution means and to take appropriate action, which, as we point out in our brief, both houses of Congress have embraced. Both have standing committees on eligibility. And I would also submit that Mr. Kreep's suggestion about the Senate's resolution with respect to
eligibility is there's also Article 20 that we're not talking, 20th Amendment, that seems to deal directly with the qualification question, but of the president-elect. I mean, there's another period we haven't talked about, which is between the election and the inauguration. And that amendment seems to deal with that.
And that amendment, once again, which supports, I submit, our view, is that it devolves responsibility to Congress.
Well, it doesn't exactly say that. It says, it doesn't say who's deciding on the qualifications. It says that Congress can provide for the case where neither the president nor a president-elect or a vice president shall have qualified, but it doesn't say declaring who shall then act as president, but it doesn't say who decides that.
But it says that if there is a difficulty, then it's the Congress that decides.
No, it doesn't say that. It says if there's a difficulty, they can decide by law what shall happen if neither one shall qualify. But it doesn't say who decides whether they qualify.
But that's, I think, how Congress decides, is by law. Presumably they would pass a law determining who the correct president was in the event that it was determined that the president-elect was unfit or ineligible or unqualified.
That's so obvious.
Or the Supreme Court might come in and decide the election.
Or the Supreme Court, Your Honor. These are interesting questions, and I don't mean in any way to disparage them, but I don't know all of the answers, other than to say that I do know that that's not the case before the court, that these individuals were not candidates, and these individuals, accordingly, did not have standing.